So, welcome everybody. I'm Nancy Salomone. I'm one of the 3 DR judges in the district court, chair of the other 2. We planned this, I feel like I'll give you a little overview of how we planned this and what we imagined it to be, and then you guys are welcome to have the space to turn it into what you think would be the most useful for you, obviously within reason. When we first set this up and I started to talk to the folks from BCBA and your fearless leaders, I think we had talked about having an update about what was happening on the DR bench with the public health crisis. But that kept evolving because what we imagined was that maybe around May and June that we would have a new return to something consistent. And obviously that hasn't happened anywhere in the country, nor has it really here. But when we realized that maybe we weren't going to have a brand new normal, we also had 3 brand new judicial officers, Judge Lindsey, Judge Collins, and Magistrate Mallavarapu, who is in a TPO hearing that she just got called in for about 20 minutes ago. So she knows that she will join us, but it might not be right away. And so then it evolved into, I thought maybe you all would benefit from getting to know all 3 brand new people. We also have a bunch of brand new procedures. So I thought that perhaps I could use this time to let the new JOs introduce themselves to you, tell you a little bit about them, and then we can dovetail into what is happening on the bench now if folks still have questions about that. I think we're all super happy to take questions from you as long as they're not about individual cases, and we can make this pretty interactive after the introductions. So that was my vision, but I'm happy for you all to take it in another direction if you want. You want to take it away?
Sure. I'm Dia, Judge Lindsey. I just was appointed April 1st. Before I was appointed, I was an assistant county attorney. My clients were all of public safety for Boulder County. So emergency management, the district attorney, the sheriff, anything public safety I handled. I practiced mainly 1983 cases in federal district court and a few state cases brought against peace officers or the district attorney in state court, which was very, very few. Before that, I was with the Dependency and Neglect office of the county attorney. So I did that for 7 years total. I did it for 1 year in Weld. Before that, I was a criminal defense attorney. So I did that, started at the PD's office, and then went into 3 years of ADC, doing high-level felony cases as you end up doing. And then, so that's me, kind of in a nutshell. Before that, I was a exercise physiology type individual, ran a health club, some other stuff. I was a dancer. I don't need to get into all that if you want to. But, and then family law, I did about 3 years. So welcome. Welcome to my courtroom. So I did that when I was in private practice, when I was doing the bulk of my stuff with ADC. I did respondent parents at that time and family law at that time. So it's been a long time for me. I'm looking to all of you, and some of you I recognize from my courtroom already. I've learned a lot from you already, so keep it coming. And I think that's about it.
I'm Keith Collins, and I think I know a lot of people in here, at least a lot of familiar faces. I was appointed to the district court bench in May. Prior to that, I served as a magistrate here for about 2 years prior to that, and I was doing our civil work as a civil magistrate. For the last 6 months of that, I started managing, handling minor DR issues, non-cons, ISCs, and things. But the extent of my DR knowledge has come really in the last few months. Prior to becoming a magistrate, I was in private practice doing primarily criminal defense work. I'd also had several years of experience in dependency and neglect cases, and worked part-time as a judge in Denver and for the city of Westminster. Like Judge Lindsey said, we're kind of guzzling from the fire hose right now with DR, and so far my interactions with the bar have been largely positive. I mean, I think everybody's aware that we're fairly new to the bench, and is helping educate us on the law and kind of common practices, if you will. And I certainly appreciate that. I try to be very approachable with attorneys and really thoughtful. And I can also say that, everybody always asks what kind of assignment you have, and I tell them I'm on a DR rotation. They're like, "Oh God, DR, how do you do that?" But quite honestly, one of the things I loved about doing criminal work was the interaction with the clients, and kind of that satisfaction of feeling like you can make a difference in the lives of the families and individuals you're working with. Doing civil disputes for 2 years and working primarily with attorneys in 99% of those cases, with no interaction with clients directly, I have found that I really missed that, and I do enjoy that aspect of it very much so. I kind of bring somewhat of a hands-on approach. I'm very solution-oriented approach, and do what I can to kind of minimize the litigation and contention between the parties, and really encourage not only the parties but counsel to do that as well. I mean, my kind of philosophy is it's really in the family's best interest to try to resolve these cases as efficiently and effectively as we can. And I think sometimes in an adversarial system we can get caught up in the fight and lose track of what we're really trying to accomplish there. So I do enjoy the DR work.
I hoped maybe we would kill enough time that
I don't-
Magistrate
I- yeah.
Mallavarapu would be here, but it looks like it's not destined to happen.
If we can just jump in. Hi, Judge Salomone, Helen Tollerton. We had been communicating
Yep.
via email, and I know that back in, May or June, one of the concerns that you raised was obviously the backlog, which, so I think that's a pressing query for a lot of us in terms of how has the bench experienced relief bringing on the new magistrates and sort of, as well as expanding authority for the post-decree cases, and allocations and et cetera.
So let me talk a little bit about changes that have happened in the way that we're managing cases that I think were effective. I can't even remember the dates now, but maybe around July 1st.
Mm-hmm.
And then I can speak to what I see from backlog, but I'm interested in what everybody else's experience is because I did not come with stats. Although I was sitting with Judge Mallavarapu in front of some of you a couple of weeks ago, and he did come with stats. So I can repeat some of his stats for you all now. So what changed in July was that, number one, we got a new magistrate who you're going to meet soon. And so that brings our DR judicial officer total from 4 to 5 full-time positions. That allowed us to change around the management of some of the cases and how they flow. Those of you who've been practicing DR around here for a long time knew an old system where Magistrate Haenselman did most of the financial matters, whether they were pre or post decree, and the judges did permanent orders and most child-centered matters, whether they were pre or post decree. And we changed all of that. And now the flow of cases is that when a case first comes in, it goes to the district court judge. The district court judge keeps it for all things. I'll get to a stopping point and then I'm gonna go back to you. The district court judge keeps it for everything from financial to children and everything in between, TPOs, PPOs, through the point where it's 1 year post-decree. And then at the 1 year post-decree point, all issues then go to the magistrates. So the district court lets go of it and the magistrates pick it up. The thought behind that was a number of things, but in significant part, it was about realizing that many families in high conflict will stay in litigation for years and years and years of children's lives. And when the district court judges rotate, that subjects families to every 2 years or so, a brand new district court judge who has to get to know the file. And, you know, given that these are the highest conflict families, there being, I think, if not actually, then certainly a incentive for a lot of relitigation of things that were settled, because when you have a new person in the chair, then maybe the person in the chair is going to see things differently. And so the idea was that when everything goes to the magistrates who do not rotate post-decree, then those magistrates can have a relationship with those families and the person in the chair doesn't change. The other thing that also motivated this was that I think there was a lot of confusion both internally and externally in terms of where pleadings would go. And we were finding, especially as staff turned over, which we've had a ton of, that things would go to a division and then go back again and then go somewhere else and then go back again. And so there was just a lot of confusion about what goes to who and when. And so we hope that the new structure will be simpler and have less confusion because of that. The assignment of post-decree cases is even to Magistrate Mallavarapu, Division M, and odd cases to Magistrate Haenselman in Division T. So regardless of who was your district court judicial officer pre-decree, if your case has an even number, it goes to one place, and if it has an odd number, it goes to the other place, and that's where it stays.
And my name is Mandy Walker, and I'm a non-attorney mediator, and most of my clients are pro se clients. So can you speak to how the process has changed for pro se clients? Because I think before Magistrate Haenselman used to handle all of those cases.
Right. So the district court divisions are now doing all ISCs with a lawyer on either or both sides. The pro se parties are going to ISCs as they had before with family court facilitators. The district court judges are now doing all non-cons, so one lawyer or no lawyers. I think Magistrate Haenselman used to do probably the vast majority of the non-cons, and now the district court judges are doing all of those. The pro se parties, though, still have the same relationship with the family court facilitator that they always had. And we have had turnover in the family court facilitator's office, but we have a new family court facilitator who officially starts, I want to say next week or the week after, the 27th of September. It's Tanya Pack, who many of you know from the self-represented litigant coordinator office for Just Ages. She doesn't officially shift her role to the FCF office until September 27th, but she's already in with both feet. We had turnover at the Sherlock level, the FCF level, and every division CJA, I think, is either new within the last 6 months or in a new role from where that person was 6 months ago. You see Jesse Cross is here. Jesse Cross is Jesse Maben, same person, new name. And Jesse was Magistrate Haenselman CJA and now is Judge Wheeler CJA. And
Lindsey.
sorry.
Okay. My name was Wheeler for a very long time. Some of you know that.
Same person, different name.
Yeah, same person, different name.
Sorry, I bust that out.
It's okay. I just don't want people to be confused about it.
And so I think you are an example of someone who has had continuity for a number of years, but even your role is different.
Yes.
As is Magistrate Haenselman's and mine. So almost everyone is new. Folks who aren't new are in different roles. And so my overall message is, I guess, twofold. One, be super patient with the staff because everybody is new or in a new role. And two, if you are emailing someone that you emailed 3 or 6 months ago, and that person doesn't answer you, it's probably because they're not there anymore. We had a a kerfluffle with our auto reply. I didn't realize that it times out after a certain amount of time. So like Ike was my CJA until June. I discovered just recently that the automatic message that had gone back to people who emailed Ike that said, I'm not here anymore, email this person instead, timed out. And so a number of people I came to learn were emailing Ike and not getting the return message, and we're just waiting for Ike to communicate back, and that's not gonna happen. So I guess because he's in California and he doesn't work here anymore. So I guess an overall message is check who you're communicating with, especially if you don't get an answer back, and be really patient. It's been a tough. So it was. I mean, I don't have to tell all of you guys because I know it's been tough everywhere. It's been tough because of the public health situation. It's been tough because things are evolving really quickly. It's been tough because it's tough for families out there. And when it's tough for families out there, it's tough for you guys, and then it's tough for us. And it's been tough because we are really having a lot of trouble getting and keeping staff for a lot of those reasons. And then I want to be super conscious and let you introduce yourself because I've been jabbering. But I think to loop back around, I don't think that there is a DR backlog of cases, meaning that we're moving them as quickly as we were before. Our caseloads are not any higher than they used to be, you know, within the everything ebbs and flows all of the time. But there is a massive impact to particularly the criminal cases in the district court divisions, and the massive impact to the criminal court divisions has caused the criminal divisions to ask the DR judges to not just kind of be there to help informally, but we have a new, more formal system of how the DR judges can become the sort of relief valve for the very backlogged criminal system. And the way that that is that 1 week in every 3, each of us is setting many less settings on the trailing docket. So we used to tell you that something was available and we'd fill 10 or 12 slots a week. Now we have reduced that number because the presumption is that the DR judge is going to be in a criminal trial 1 out of every 3 of our rotation weeks. So that just means way fewer settings for you all, like a reduction by a 4th or 6th or something. And also fewer judicial officers doing DR in some of the weeks, because we're thinking, and this hasn't always been true because not always is there a criminal case to fill the slot, but hypothetically speaking, instead of doing all DR all the time during the trailing docket trial weeks, one of us is devoting every 3 weeks to a criminal trial, which just means that our attention is divided between tasks. So the numbers aren't up, but the judge resource availability is a little bit down until we work through the criminal backlog, which we are being told at the earliest, probably next summer. Let's let Magistrate Mallavarapu do an intro now, and then happy to go back to your questions, or if you guys think I forgot anything you want to add.
Yeah, no, I mean, we can do that. And then
Okay, I'll just be very brief. I'm Sangeetha Mallavarapu, and I'm a magistrate. And I just started at the end of June. So I, as Judge Salomone already told you, I'm doing post-decree domestic relations cases ending in even numbers. So if I haven't had a chance to see you in my courtroom yet, I look forward to seeing you all in the courtroom.
And what is your background? We had to do that.
Oh, I appreciate that. So my background is primarily in domestic relations. I worked at the Harris Law Firm for almost 8 years, doing only domestic relations cases. Before that, I worked at a couple of different big law firms doing employment litigation and general civil litigation.
And this, I think maybe this might go to the question you asked earlier. The family court facilitator is now going to be hearing all the initial status conferences, including the ones that used to be before the magistrate. So for those of you who mediate, I know that you are one of those people, the expectation that parties could come to the initial status conference and have that be their final hearing will not always be the case any longer, because the family court facilitator can't convert it to a non-con and take the testimony. So that is one change, but we will be able to get those hearings set on around the 91st day. I don't think there's been a problem with that, but it just occurred to me that that might be one change that will impact some of you all.
The only other thing, oh, go ahead.
Following on from that, for parties who have no minor children have reached a full agreement and are filing an affidavit of non-appearance. My understanding is that they file all of that paperwork up front. Would they still have an ISC?
And we've changed that process a little bit too, in a way that I think really benefits the parties. Previously, when parties filed all their documents, they would be tickled directly to the magistrate for the 92nd day. So even if there was a missing something, the parties wouldn't know about it until after the 92nd day. And now the family court facilitator will be reviewing those documents ahead of time, and she has authority to set an ISC if necessary. So that will help people catch things ahead of time, and then if the documents look like they're ready to go, then they'll be tickled for the judge. So I think that's really a great benefit for the parties.
Sounds like it will be. Thank you.
And keeping in mind that we're still dealing with some of the backlog, and we have a new family court facilitator, so we still need a little bit of time to get our feet under us, but we're moving in, I think, a really good direction.
Yeah, that's all I was going to say. You know, our DR team across the board here is virtually all brand new, and we've really changed the process. We've put a lot of thought into the changes to try to come up with a better system for everybody involved. But, you know, obviously we can't anticipate how it's necessarily going to play out. We've only been doing it now for a couple months. You know, we think it's probably going to take about 6 months maybe for us to really get a good sense of how it's working and if there are some glitches there that need to be changed. So, you know, it is still a work in progress, but I think so far the feedback we've gotten, and I think what we're seeing is most of the changes have been positive, but there's still little kinks that come up here and there, you know, as we continue to work through it.
And I think some of the protocols have some space to adjust in smaller ways if we discover that the things that we anticipated happening aren't coming true. Like I mentioned that the cases stay with the judge until 1 year post-decree. Frankly, we chose that 1 year post-decree because we wanted to encapsulate basically Rule 59 motions and Rule 60 motions and things that were really not a change in circumstances as much as I don't like your order or I don't understand your order. So those purposely should go back to the judge, but the year is a touch arbitrary because other than trying to figure out how we encapsulate really reconsiderations, not new circumstances, but also get the caseload numbers to look right. We took a guess that a year was about the right amount, but that's one of the areas where we thought that we might have flexibility to adjust if in fact a lesser or greater amount of time actually serves the purpose, but it's a different number than we thought. So that's an example of something that might get tweaked if 6 months down the road we have misassessed the work volume for everyone, for example.
Another thing is that the magistrates have the ability to set matters on the trailing docket as well. So a lot of times, obviously, the benefit in front of the magistrates, you can get a firm setting, but you're not necessarily guaranteed that. That's going to, I think, be dependent upon the type of hearing and what their dockets look like.
So just for my own clarification, are you saying that the case will stay with the same judge regardless of rotation for up to a year? Because it's a 2-year rotation, but some cases obviously might start kind of late.
No, but thank you for clarifying that. That's
Okay.
not what we're trying to say. It'll stay with the same numbered division. But if a different
Okay.
human occupies
Okay.
the numbered division, it goes to the human in the numbered division.
Okay. Yeah, because I have a couple of cases down in La Plata, and they try and do one case, one judge, so that it's always the same, and so it just seems like it's gonna be more post-decree, we're gonna try and stay one case, one judge, okay.
And,
Our
and-
rotations just don't allow for us to carry cases over.
And not only that, but it's also not one case, one judge because of the trailing docket. Because as you guys all know, and you've been dealing with for years and years, something that is at home in Division 12 could get assigned to 14 or 1 or 6 or 4 for its permanent orders hearing.
Yeah.
So that is definitely unchanged. And the continuity of judicial officer is really post-decree with the magistrates. It's not, nothing has really changed pre-decree.
Is the 1 year from the filing of a motion or from when the hearing was held?
From the date of the decree.
Yes, but in a subsequent, like if you file a motion in the 11th month, would that then be heard?
Oh.
We'll have to
so
see.
it's being loosely interpreted.
Yeah, who's filing it?
It's being loosely interpreted. We arm wrestle.
Yeah, that is a sticky wicket, as is the question of what about stuff that was underway when we made the change. I've kept a handful of stuff that was underway when we made the change, and I think I've pushed off a larger handful of stuff, and it depended on how underway the underway was.
All right, good meeting.
I'll ask another question. I was excited to see that you've started the electronic filing for pro se parties. I know it was only a week ago, but was wondering if you had any initial responses to that or reactions or.
To be honest, I don't know. By the time it gets to us, we don't have any idea who filed it, whether it was filed electronically or that they walked it in and filed it. So as far as how it comes to us, we don't discern a difference. And I haven't noticed like a huge influx in my inbox either, so.
Right. I mean, for what it's worth, I think it makes it a lot more convenient for pro se parties. And the ones I work with, I use an electronic signing program, so they don't have to meet to sign, and they don't have to print documents out, they can just upload it. And I think the people that I've worked with in other districts that have used it have found it helpful and pretty easy to use.
I haven't seen a single thing that I can clearly identify as a e-filed pro se filing. I don't know that I would notice if I did. You know, I think the thing that would probably tip me off would be if there was a timestamp on the top
Right.
that was not when the courthouse was open. That might do it, but I haven't seen anything. I think it's probably too early to answer that question, but it's a good one. I think it's just too early. Has anybody else seen it?
Does the 20th judicial website have everybody in where they're supposed to be and whoever the assistant judicial officer is, and the contact information? You were speaking about Ike,
Yeah.
and so I'm wondering, is that when you need to talk to or email somebody, you got the right one on the 20th website?
That's a great question, and our administration is really good at keeping that updated. So that's probably the best practice is when you're trying to reach somebody at the courts to go to the Boulder County homepage and then go directly to it. So if you try to contact any one of the judicial officers, it will default to their judicial assistant that's there now, which may be different than what's in an order that we had issued 3 weeks ago. So, great point.
I think it's current, but I'm making a note to check.
Just to clarify, when did Ike leave? I feel like I just emailed him.
Yes, probably did. He left at 2:12 in the afternoon.
Something.
You were all there.
No, it was like late June.
Okay.
Yeah.
But I
The
go,
list is fairly current.
Thank you.
As
Is
fast
it?
as, yeah, we review it every time, and it's, we're noticing all the changes and changed CJs, et cetera. So I think whoever's in charge of that is doing a really nice job.
Yeah, that thing's coming out like
And
every other week.
Just an FYI, we have had a lot of turnover, particularly at the CJA level. We've obviously addressed that here with our administration, and they've addressed it with the state. It is a statewide issue. Every jurisdiction is having very similar issues for a variety of reasons. So, just so you understand, it is a topic of discussion, but there's only so much that we're able to do here locally to address that.
I can talk about
So I'm just curious, since so many of our judicial officers are now new, how much substantive law and background and case law are you wanting for us to prepare?
Like a ton. Like as much as possible.
Okay.
No, I mean, we've all been lawyers for a super long time too,
Yeah.
and I've had to change careers about 4 times, so we get up to speed pretty quick, I think. But again, whatever you want to throw out in a hearing, or we can't tell you what to put in, but yeah, I learned something new literally every hour, so it can't hurt. That said, we know you're busy too, so I think you can juggle that, but we're picking it up. It's fun because we're able to pick it up and do fun things, if you will.
And I think Judge Lindsey and I, because we're both new to DR, we're not afraid to say, look, we need some education on this area. This is something that I need to research and want input from. So I've had a number of hearings where I've actually said that to the parties, that this is an area that I need more information on.
Or I'll ask for, I think I did it to Susan last week.
Yeah.
Sorry. But I'll ask for closing arguments. I'll ask for closing arguments on cases with a lot of issues, because you know better, to solidify those issues for me on both sides just makes it easier for everybody. I don't do that. In fact, I think I've only done it twice, so not very often. But, if I get busy or we've had a ton of hearings or something like that, I might request that, and I think that's to everybody's advantage.
Thank you.
I was gonna speak to time out from ripeness of issue to order. I think I should only speak for myself and then let other folks speak about it also. I have not had an empty inbox since 1955. So there's a ton of stuff in my inbox. Some of it is quite overripe, and I will tell you how I figure out what I do and in what order, because I think that sometimes folks call my CJA and you might wonder, how come this thing's been ripe for 2 months, but I got an order in this other thing and it only was ripe 3 days ago? So I can, I guess, say, speaking for myself only, how far out am I and what am I doing and in what order? The complex financial but not child-based order is the slowest order that you're ever going to find. I struggle to get them out in 90 days. If it's complex financial and it's been ripe for 90 days, I know I have to get it out because that's my obligation to the Supreme Court based on their directives of how fast we have to manage things. I have, I think in the last 6 months or so, occasionally missed that 90 days for the first time, and I know that I've missed it, and we're all just doing the best that we can. If you have a complex order that doesn't have child safety or isn't holding up something else happening, it's going to be the slowest, at least in my division, and don't hold your breath before 90 days, honestly. Obviously, there are things that have to be fast-tracked by the statute. I also try to take things on faster that I can do faster, because a lot of our days, a lot of the time, consist of, I have a 7-minute bite between this hearing and this hearing, and then I got a 4-minute bite between this hearing and this hearing. And then I thought I had 21-minute bite, but it actually became a 3-minute bite. And so stuff that I can't do in 15 minutes, it might be 2 weeks before I have a period of time that's longer than 15 minutes. And it just is what it is. I know you guys deal with it also. The stuff that has to be decided because it's holding up the next step in the case. So like if there are contested nominations for CFIs and I've got a permanent orders hearing set, I'm gonna try not to sit on that for 2 weeks because I realize that I'm endangering my own permanent order setting if it takes me 2 weeks to choose between 2 CFIs. But there are days, and maybe more of them than not them sometimes, where I don't even know what went into my inbox today because I didn't look at it today. And I don't know what went into it yesterday either because I didn't look at it yesterday. And so if you have a kind of case where you feel like maybe it got missed or maybe it got lost, it's especially if it's an issue that's holding up progress, or if it is a kid-based issue where there is instability for a kiddo because I haven't ruled yet, give my CJA a call and ask her, or really probably drop her an email and say, what's up with my order? And she'll pass that along to me. If you have a Rule 59, if you have a financial only issue, if you have a permanent orders issue where the urgency is the parties would like to get divorced, but that's really the end of it, don't hold your breath. And you're welcome to contact me, CJA, but she's gonna tell you that you shouldn't hold your breath. And there are sometimes like Rule 60 will come in, and I think, oh, maybe I can just dispatch this so that somebody doesn't spend money to respond and then reply. And I have a good intention of doing that, but more often it doesn't happen than that it does, because everything that I already ruled on goes after things that I haven't yet ruled on. So I think that's just sort of a level of expectation maybe that if you could set with your clients, because we've set it with you, that might help everybody. I think I'm farther out on orders than I was a year ago. Like the same thing takes me twice as long. And that has to do with the newness of staff. It has to do with the shortage of law clerks that I haven't even talked about yet. And it has to do with a ton of time is being spent on a lot of administrative stuff that didn't used to exist. So like when you hear us say that we don't have a backlog, that doesn't necessarily mean that we don't have a slowdown. I do. I have a slowdown.
And the other thing that's kind of going on is there's a big overturning of filing clerks. So I know I don't get stuff in you might file something on Thursday, I won't see it until maybe Monday or Tuesday. So keep that in mind. And I'm like, why am I just seeing this today? I thought my inbox was empty, and then it's like boom and full. So keep in mind that we may not see, and I think about things because I was a lawyer, 5 minutes ago. So I'm now on the bench, and I remember being a lawyer going, it would take her 5 minutes to just look at this. If she would just look at it and file it. And now I'm in court, and if and it's really like, now I'm like, oh yeah, I guess that should be quiet now. No, but it's just everything is in flux because of all the turnover of all these individuals that do these different jobs. So I guess I'll go. I don't necessarily have like that all figured out like this. I just haven't done it long enough, but I do come from the school of I have been where you're at. I have been waiting on orders for clients, and talk about waiting. I mean, I've waited from the federal district court for 2 years, so on massive cases. So. But that said, I don't mind. I mean, like I just had this issue where one attorney was waiting for me to rule on an order for publication. And I just missed it. I mean, it came into my inbox, and then the attorney called, and Jessie sent it to me, and she said, hey, you've got this order. You should grant it. And I'm like, I'm granting it. I'm all over it. And then I sent it from the road. I work on, all whatever. and I was on I-70 and it didn't go through, and I didn't know. So I got another email from the attorney, and I don't mind that because I didn't answer it judiciously. You know, I want to get things out to you as soon as possible because I recognize being where you are. So I do want that. I don't want that to be my MO ever. And just recognize that there's probably a good reason that it's not getting out to you. But if you're wondering, just call. Jesse will let me know right away. And typically, if you're waiting on something and I haven't looked at it, I will probably look at it with that email. And I'll either say, I'm not going to get to it for whatever reason, or you'll see the order the next day or something like that. So that's sort of, and I don't have really, I don't have any, method to the madness yet. That's kind of how I'm rolling is let me think about what your families and what you attorneys are going through and try to do things as best I can with that in mind. But
well, since we're talking about orders, I actually have a question for you all. When there are two attorneys on a case, do you all generally prefer to draft the proposed orders yourselves, or do you prefer the court to draft the order?
The court.
The court? Okay.
Overwhelmingly the court.
Okay. Yes.
You get attorneys, and you're going to spend presumably figuring about every freaking sentence in there, so overwhelming.
And periods.
Okay, that's good to know.
yeah.
Because sometimes I think, well, would it be faster, to have the attorneys do it? But then maybe that's not a good idea.
No, that's not fine.
I think it depends. I think if it's a stipulation and the attorney is agreeing, how to resolve the issue, I think it would be okay to draft the.
Well, yeah, we get those. That we love those, obviously. It's just like you do, but
Right. I just was talking about when you have, a big, long hearing and then somebody has to do the order at the end. But it sounds like the overwhelming response is the court should do that.
It used to be that we would draft the orders, and if I watched the difference when the court started doing it, so much better.
Okay, that's really good to know. Thank you.
Perhaps for us as practitioners, because we do have the option of providing proposed orders for the court. And, how helpful do you all find that when you're drafting your own orders?
it just depends. Like I had somebody supply me with an order on a status conference last week or the week before, because the issues there was a ton of them, and there was nobody on the other side. And so I allowed the attorney to draft the order, gave some time for a response. That party hadn't been playing, probably wasn't gonna play, but gotta give that time. So that made it easier for me. If it's gonna be two attorneys fighting it out, and it's gonna make the fight longer based on some sentences and some words, nobody's got time for that. I'd rather just put it out. That's my position.
Can you speak to the timing of issuing confirmation orders on PCDM decisions? Like, do you issue them as soon as the decision comes in, or do you wait 30 days to allow for a filing from the parties?
I've just been adopting them right away.
Yeah, same.
And when we see them.
Yeah.
That's the caveat, is when we see them, depending on how they come in, and kind of where they are in our inbox. So we may not see them right away. It may be a week or two, but I think most of us, once we do see them, will move to adopt and approve.
And this is part of the transition, and what has happened is not only have we had turnover in terms of people moving on, but we've also had a lot of people moving to different positions within the building, and some of it is also a training. So if you do need to make that phone call, it's certainly for my division, make the phone call.
And
All I was going to say is I had mentioned kind of 6 months time period. We really, we're doing a lot of training right now. Judges are spending a lot of times with our CJAs and kind of teaching them, and our law clerks. We're now fully staffed with law clerks for the time being, so each judge will have its own law clerk again, which will help in this, but it's just going to take a little bit of time for people to kind of be up and trained and up and running. It's not uncommon that something that we needed to look at gets thrown into the ROA and nobody sees it at all, or something that might be time sensitive is put in our inbox and nobody flags it. So it's those kind of things that are still kind of happening, and that's a training issue obviously upstairs with us, but it's also a training issue downstairs in the clerk's office, which has had basically complete turnover as well. I feel like at least for the DR team that we're pretty settled now. We got a good group of people. We're all very excited, and everybody's eager to kind of learn. But it's just going to take a few months, I think, before we kind of get through those initial, learning pains.
Mandy, to go back to the PCDM question specifically, I saw that you had sent an email to Judge Bakke that reminded her that we all agreed that the division would send the affirmation of the PCDM order to the PCDM. She sent that to me. That might not happen because it's just, we are training so many people, and truly there are a handful of concepts that they need to really master when it gets to like safety issues and stuff like that. I think if you're the PCDM, you can rest assured that we're going to confirm the order, and then somebody might move for a de novo review, and that's how it gets settled. I'm not going to not confirm the order just willy-nilly because I don't want to, and I'm not going to wait for someone to argue about it because the statute has a process for how you argue about it later. So if you're the PCDM, you can assume that I'm going to approve and order your order, and then what happens next happens next. But I think the
follow up after like 30 days. I don't
Sure.
want to follow up too quickly.
Sure.
But I put a ticker on my calendar to say, follow up on confirmation order for XYZ. And I just want to make sure that I'm doing it appropriately and not.
Totally. And you can follow up faster than that, because one of the things that is happening because we have new people in the main clerk's office is they're getting to know what goes to the ROA and what goes to the judge. So there are a lot of things that they're doing their best, but it might get filed and then they don't recognize it as something that needs to go to me. And so it sits in the ROA and I don't even see it until you make a call.
Okay.
That's another good reason to reach out.
Yeah.
So sometimes that happens. I've had that happen a few times, in fact. So if it gets later, definitely reach out.
I don't think anybody's ever going to be upset that you reached out, and I meant to say what I said only to set expectations, not to discourage you from reaching out.
Unless you're reaching out like twice a week, just because you have nothing better to do, then maybe put some boundaries. What else? This is your time.
What else?
We're doing so great that that's it. Right.
I have a question.
Oh no. Just kidding.
Settings on the timing, like how much time you get for hearings, historically has been, this is what you get, I don't care what you have to say about it, and this is how much time is allotted for temporary orders hearings and the like. Is there a shift in that concept of how much time you're gonna get? Say PPO hearing, you get an hour, that's all you're gonna get, or the temporary orders, not gonna set it for more than 2 hours, and this is what we're accustomed to, and so I'm wondering if we get to be retrained so that we might get.
Well, as you know, this is probably where the question's coming from, I'm wondering. In my courtroom, so there's been, and I may have been a little bit frustrated about that issue, but there's been a few PPO hearings where there's 7 witnesses on each side and it's set for an hour. And I'm like, if we're set for an hour, I come in thinking we're set for an hour, and I expect the attorneys to deal with that the best way they can in that hour with their best witnesses and their best case, their best evidence. And if you really believe that you need more time than that to combat the PPO or to present the PPO, then call, as I told Ms. Latimer, call my clerk and say, we're willing to kick it out further, but we need more time. I will grant that rather than have you come to my courtroom and say, we need more time, Judge. And I'm like, I ain't got more time. I don't have more time because I got the next thing. And you know I have the next thing because you've been practicing here for 25 years. So that's, I don't know, and I'm coming from, I don't know what's been going on or what you've been accustomed to because I took the bench 4 months ago. So what I'm telling you is my expectation is in my courtroom is that if you've been practicing in this jurisdiction with DR, you know more than I do about what you need to meet the standard. And if you need more time, if you can get that more time by agreeing to a continuance or not, do that. Because I'm happy to hear, I want to hear your best case, of course I do. Especially on an issue that's a DV child issue. That I want to give a lot of time to. But I'm not gonna, I'm not gonna hear that, you know what, we need more time, Judge, on the day that we need more time. I'm not gonna have, I'm not gonna be real sympathetic about that. So if there was like a feeling that I don't know about, like a culture that I didn't know about, where you got your hour and that's all you got, I apologize for that because I didn't know about that.
You know, I don't think you need to apologize, but there has been predecessors where you open your mouth about the amount of time and you almost risk that your hearing's gonna get set completely different. You're gonna have less time, or it's gonna get set completely the opposite of what you need it to be.
Are they still here? Because I can talk to them. I have a way of people.
So that's just where some of us
got you.
coming from with that, so we're keeping our mouths shut, but I'm all gracious for the idea that we could raise the issue that, yeah, we need some more time, and you, of course, knowing that sometimes the other side's gonna raise holy heck because they don't want more time because they want it set a certain way or set really quickly, whatever.
Yeah, I think, so just so you know, like, I also grew up in the judge world and have had every number of judge that doesn't give a shit, but we do. Sorry, dang it, we're on tape. I knew it was but I think this is a really thoughtful bench, and we're gonna look at the case, we're gonna review it, we're gonna see what the issues are, and we're gonna make determinations that are thoughtful about the family. Period. At least I am. I can't speak for, I've known these guys a long time. Yeah. I mean, like, I think we're gonna do that, you know, so but we're gonna weigh everything. You know, if you got some kind of relationship with an attorney, another attorney, and it's been a fight going on for a minute, and I can see that, those are all things that are gonna get weighed, right?
I think for Division M, I would, be happy to give anyone additional time, as long as they request it in advance and there's a good reason for it. And if the parties happen to be there and it's clear that it's not going to finish, if I have time in my day, I'm happy to make more time. It just depends on what's happening in my schedule. But I think for a PPO hearing, they typically will get set for an hour. But if there are two attorneys and at least one of the attorneys wants more time, I think they're welcome to call the CJA and request additional time.
So I'll jump in with, here's the problem from the perspective of, I think the district court divisions are more confined by this. When it's a issue that has a statutory time limit where we have to hear it within 14 days, our calendars are pre-slotted as like, this is the hold that we put, and it's from usually 10 to noon. Sometimes we try to stuff 2 of the statutory time limit ones, 10 to 11, and then 11 to noon. And so I might want to give you more time, but unless you waive the time limit and you're willing to go out a ways, I can't, because I'm already set through that day, and I only saved one slot that's 1 hour long for this many hearings to be held this week. So I'm happy to give you more time, but if there's a statutory time limit, you guys have to agree to waive it, or else I can't, because I usually won't have it.
And you know that. You know what the statutory timeframes are. You know what we're dealing with.
And understand how our dockets work. So Mondays and Fridays are the days that we do ISCs and non-cons and PPOs and motion to restricts and all of those, right? They're like, we're every 30 minutes or an hour, we're in a hearing all day. Mondays and Fridays typically. So, and those get booked up, and as Judge Salomone says, you know, we only have a slot left, and that's it for those types of hearings. And then the, you know, Tuesday through Thursday is a trailing docket that we can't set on. So it is kind of, part of it is just how it's predefined. With that being said, to echo what Judge Lindsey was saying, I'm not familiar with how it's always been done, and nor am I necessarily going to be bound by how it's always been done. I'm happy to assess each case as it comes in and address it. You know, some of that, you know, learning more about how it's been done to give me a good starting point, I think, is a reference. And as long as I don't feel like it's being abused, I'm happy to entertain discussions about, you know, an appropriate time setting. What, you know, I think is incredibly frustrating as a judicial officer is showing up for an hour or a 90-minute hearing and the parties are like going at it like it's a half-day hearing. You know, and we're like, look, this is the time you have, and you just ignore us and you keep kind of going along, and we're like, we're out of time, or we're going in, you know, to our next hearing. So
It's a delicate balance.
you know, so it is much better to have that conversation up front, and I don't think you risk any repercussions of asking, you know, for more time. Worst we're going to do is to say no.
And then on the ones that aren't statutory time limited, like when we're setting on the trailing docket, I'll try to shove every permanent orders hearing into one day that I can. And if there are complex financials and you tell me at the ISC that you think it's too complicated to do in one day, I'll probably push back a tiny bit and then I'll give you two. But if you say that you want to because you really, really don't get along, that doesn't make it any more complicated, and I don't want to spend 2 days with it when I could have done it in one. So I don't think there's much in the way of changes to, that's how I thought it was mostly done. Super simple stuff, not a lot of assets, not a lot of conflict. I'll ask if a half day works. I'll always give you a full day without very much pushback. If I suggest half and you say full, I'll say okay. If you want more than a full, I'll probably push back at you in the ISC, and maybe at the end I'll give it to you and maybe I won't. Because right now I'm setting, the first things I'm offering people are now February. And so recognize that like one of my 3 weeks is a 5-slot week, and if I give you 2 days, now I can only set 3 other things and then we're done with that whole week, and I'm out in February. So a lot of it is, there's a lot of back and forth between, is it on me to give you more time or is it on you to pare down your case? And I think that's where we're always like, can it reasonably be pared down if you tried harder? Or do I need to give it extra time because the answer to that question is?
Well, that's where the active case management comes in. You know, and that's always helpful for us, as I think, as practitioners. Because certainly when I've said, well, I think we need 2 days because we've got hotly contested kid issues and a PRE, et cetera, and we've got all these, you know, highfalutin financials, you know, I might get that initial pushback that, like, Judge Butler's like, well, I count on counsel to tell me how long they need. You know, I trust you to give me the honest assessment. So, I don't know, but I've always just kept it at that. You know, if I have high conflict child issues and big financials, I know I'm not a good enough attorney to do that in one day, no matter what. So I'll ask for 2. Yeah.
And I'll probably give you 2 if you have both of those things.
Yeah.
But maybe not if you don't.
And maybe and file in Division 14 if you get a choice. Because I was like, 2 days? There you go. Because I didn't know. I didn't know what I'm doing. I just assumed. Now I know. I learned something.
Is it anticipated that ISCs are going to remain online, or is that more a function of COVID?
I think we're going to keep them online. It's super easier for everybody, right? The clients, you guys. I mean, not us. We're going to be there either way. But
That and contempt advisements, I think, those are going to remain, I think, going forward via via WebEx.
It's a huge time,
Sure.
time and
Oh, yeah.
cost saver
Yeah.
for the
Yeah.
clients, for sure.
And status, I've been doing
Yeah.
status conferences too
We're,
online.
we're all pretty open. I mean, we've been told, go back, try to get them back in person as much as possible. But I think we're all fairly open to requests to appear via WebEx for, fairly small, minor hearings.
Thank you.
Is there a consistent time frame that you will prohibit temporary orders prior to permanent orders?
I've started making that a yes for me, and I've been calling it around 45 days prior to permanent orders.
And I just mentioned it, I don't think I've got a time, but I do know that the math, if you ask me for a temporary orders hearing and haven't gotten the date, like 2 months before the permanent orders hearing, I'm not gonna grant it because I know we're not gonna get a date. So keep that, in your mind if you think you're gonna need temporary orders.
I'm not hearing them, but that was, and I inherited that, and it really did make good sense.
Was yours
It was
45 days
8
also?
weeks,
Yeah.
yeah.
8 weeks, I like that better.
And, sorry, sorry, everyone. And from time to time, something that would come up that was emergent, and that also gave time on the docket to accommodate those.
Can I ask one question just on who you want us to, Rachel said no, so I'm just gonna stop. When a emergent matter, so keep restriction or that type of hearing is set and you guys kindly just sort of boom, set it, we get the notice and it conflicts with something that is also already set, who are we pushing on in that moment?
Our calendar.
Right, but I mean, so are we pushing back against the thing we already had set? Are we contacting the thing that got double set to try and
I see your question.
switch it? Because obviously, everybody's busy. You have, maybe one case has, 2 attorneys, 2 clients, and the other case is then an unrepresented or that's your emergent one. So every case has players. What would the court prefer in terms of trying to deal with those conflicts?
A stip.
Right, yeah.
Not a stip on the, I mean, I realize that very few of those get stips on the substance, but I don't feel like I'm in a position to tell you which one should move because you know about your opposing counsel on both sides. So I would say if you get double set and you can talk to opposing counsel on one of your double set cases, move whichever one you can get their consent to move. And if you can't, I'm probably gonna leave the time sensitive one in the spot and move the other one.
Okay.
Sorry.
We just start making calls. I mean, because I just don't know what availability exists and who needs to start.
Well,
Pressure.
I think because the magistrates' calendars and dockets are so different, for my calendar, I think if I had a case with 2 attorneys, I would most likely try to clear the date and time with them first before it was set. So hopefully that wouldn't be an issue. But again, I think just because maybe it's because I just started recently, but my calendar, it does tend to be pretty flexible right now.
So when you guys do a preliminary motion to restrict and you're saying the motion sets forth, blah, blah, blah,
Yeah.
do you say the hearing is set for this day and time? Or do you call the attorneys and say,
So-
when do you guys want the hearing?
I've been setting, and most of them, these are new to my docket, and frankly, most of them have been with one attorney and one unrepresented party, and it does run into that time issue. And my docket has been flexible enough that I can accommodate movement, but I'm not gonna set it outside the 14 days, and so that's a struggle, and I have a feeling that's one of the things we're gonna be talking about again. But I have been setting, and if people just hate that, I would be willing to consider something else, but with a new CJA and the need to get those set, I'm just setting. And is that just horrible? Do people just really dislike
No,
that, or is
that's-
that okay?
I don't know, it's hard to say, that's always the way it's been.
Okay.
I mean, in, 10, 20 years now, so.
Actually, I disagree, because I have it done both ways, all the time. I have the
I always get
clerks
them-
will contact me and clear the date, and then I have other times where I just get a date.
Yeah,
When I
if
just
I
get a
have-
date, it's just a crapshoot whether or not I can do it or not, and if I can't, then I come back and beg that I can't do it, and we try to do something about it. But I have it absolutely inconsistent with whatever division, or whoever's signing off on it, I get.
So we're
Yeah,
keeping you on your toes, is what you're
There you
saying.
go.
I mean, read the orders, I guess, you know. You're gonna be all like that, we'll just read the orders.
I don't think I've really had that many motions to restrict or PPO hearings where they were even one of them was represented. I think I've only had a couple, but for the ones I've had for just, even if just one party was represented, I would clear the date with the attorney, just because I feel like I was so recently practicing as an attorney, and it was always very frustrating to me when the court would just set it, because I might have an all-day mediation that day that it took me, 2 months to get. And then, my paralegal would spend additional time and billing the client more for, communicating with the court to try and reschedule it. And it just, I don't know, from my perspective, at least right now, at this moment, when I don't, when my calendar is very flexible, if I had a case come in with even one attorney, I would contact the attorney. So you might just see variation between the different divisions.
I'm always gonna set it, because I have 2 slots a week.
Yeah, I'd say like the last few that I've sat, either PPOs or motion to restrict, like I only had a time that I could squeeze it in within that time frame, and that was it. So barring something else going away, that's all we had.
I put in my motion to restrict if there are times and days I can't make it, I'll put it in the motion to restrict, and it's a tort restrict. They've been accommodating that.
It's a great idea.
That's really helpful.
It does help.
Just saying.
Yeah, especially knowing that it's going to be set right around that 14th day.
I hate to even say it, and these guys are gonna punch me for saying it. Is there anything that you think we don't know that you think we should, that would make us do something different?
Well, they don't have them
If
all
we-
day.
Yeah, it's like-
it's only supposed to last an hour.
They're like,
should have led with that.
procedurally. I know there's all kinds of things you think we don't know substantively.
Help us help you, help us.
I have a question, because you keep mentioning staff, and certainly, we see it everywhere, restaurants are closing. Is there a real significant problem in the clerk's office with staff hiring right now, or what's going on here?
I mean, I think that there's a significant problem. I think there's a change in the workforce, right, post-COVID. And I think, the state employees are not exempt from that. And so we have seen turnover within the clerk's office and the CJA's positions, both here and every other jurisdiction in the state. We just had our judicial conference this week, and they were talking about this exact issue. So, I think there's a lot of things that go into it. We've had a lot of new hires recently. The last 2 or 3 months, they were doing interviews every week for CJA positions, both, with judicial officers and the clerk's office. So I don't know how many open positions there still are. I think the clerk's office is still somewhat understaffed, but it's much better, and I feel like it is settling down some. But it remains to be seen if that turnover is going to continue.
So help me, and this is just a feeling, I don't remember the specifics. When there's a status conference or something, if the judge kind of hints at what's gonna happen, it helps us to settle. It's like, okay, I know they're gonna do this, whether it's for or against me, preferably for, but, you just say, hey, go figure it out. I'm like, no, say something. And it's.
What do you mean, like, before we set a status conference? Or?
No, at a status conference, like
Okay.
if we're having problems and we want a phone call, and we're asking, and you say, well, we're gonna have to set a hearing. But I've had, and I don't remember the specifics, but I've had in the past when the judge has, kind of hinted, like, well, you can set a hearing if you want to, but, they do it very smoothly.
Yeah, I can't help with that.
How do you settle the case?
Yes, pretend you're Judge Mulvihill and just. You might want to think of this, or counsel, you know better than, you know, I mean, that is helpful. It is.
I wish I could be more specific, because I think I'm just so, I don't feel that new, honestly, but I feel like it's a struggle for me, because I don't want to be like, you know, predetermining what I hear, right? I mean, there's that piece where I need to hear you out before I, you know, although I don't disagree that I can look at the record and see what the problem area is, so.
If it's like, I wanna take my client wants to take the child to grandparents' house for Christmas, and the other one is saying, no, don't tell us to just go settle it. Grandparents are really lovely, like, really, you know what I mean?
Yeah.
You know,
That sounds like Judge Butler.
Yeah, it does.
You know, or if it's a financial, you haven't paid any child support.
Underline full. No?
I'm not correct, but you have to be, you know.
Yeah, I get it.
That helps settle, and we kind of know where we're going, and it helps us tell our client, look, you are being unreasonable, did you hear the judge?
It's like for all the other judicial officers, tell them, yeah, they have to be here or be slandered. That's it. You know, we're gonna
That's
talk
right.
about you.
It's fair
Well, that's
game.
true.
I'm sure it happens to us as well.
A long time ago, I remember that judges would do settlement conferences. And I don't know if they still do that or not. No. No time.
I don't
No, we
remember
want
that
you to do
too.
it.
And
We want you to do it. No, I'm just kidding. I know you can't. I said, we want you to do the settlement conference.
No, I
but
hear
can't.
you. I just remember that if you got, you know, a rock in a hard place, and sometimes you went in and the judge would say,
Strikes me that blah, blah, blah.
Yeah,
Yeah.
that is helpful. I
everything,
agree.
yeah, because people listen to
Yeah.
the court.
have any of you been in front of Angie Arkin? Yeah, I think every case I've had in front of her, she would always bring us into her chambers, like right before the hearing, and pretty much strongly hint what she might do, and then ask us if we wanted some time to try to settle it. And that would ultimately settle it, right? Then it's like, okay, well, we have this feedback, so now let's go settle it. What's the point in, you know, spending the rest of the day on the hearing? So I think if you come in and you ask for feedback and you tell us that you want that, I would be happy to give anyone feedback if they think it would help them settle the case.
Is there any space within the system, you know, to have senior judges act as settlement judges? Or
Not right
no?
now.
No.
Everything's about the backlog of trials,
Yeah.
and you know, it is, you know, taxing. And I just did one a week ago. Judge Salomone is doing one next week.
Trial, not
Trial,
settlement.
yeah, which, you know, takes away, and they're using senior judges to help alleviate, to allow us to do that as well. So that's the priority right now.
The judicial resources are super thin.
Yeah, creativity is like at an all-time low right now.
Yeah.
You know, because they're just
Yeah.
plugging holes, you know? I mean, that's why we're doing criminal trials, because that's their backlog. I mean, and it's a priority, right? It's a criminal case.
All right. Well, I got off easier than I thought I might with that question. Thanks, guys.